When your clients come to closing and they are getting a loan on their transaction, they are seeing multiple costs for title policies. Many buyers and sellers do not understand that there are typically two types of title insurance policies that are being issued: an owner's title policy and a lender's title policy. As of recent, people have been paying a pretty penny for their houses, but are now wanting to cut costs where they can and avoid the cost of insurance policies by just getting a title opinion from an attorney. It is important that you all understand the difference between the title policies and a title opinion. Both title policies are protection to the insured if there is a defect in title. As is the case with any insurance policy, a policy of title insurance is a contract between the insured and the insurer. The lender's title policy is for the amount of the loan. The policy expires when the loan is paid off and the 4-year statute of limitations for foreclosure on the lien expires. Most lenders require a loan policy as a condition to getting the loan. The owner's title policy, on the other hand, is for the buyer for the sales price of the land and improvements, which remains in effect so long as the new owner, the buyer, retains an interest in the property. An owner's title policy protects against losses from ownership problems that arose before your client bought the property, but were not known at the time of the purchase. A title opinion from an attorney is just an attorney's opinion on the defects on the property that are available via public record. If the attorney is wrong about the owner's rights to the property, the owner can sue the attorney for negligence. Title opinions can be costly, and they do not provide insurance against any incorrect or undiscovered defects on the property. Title insurance, however, insures against financial loss caused by defects in title to real estate. Title insurance doesn't guarantee that there will never be a problem, but if a problem arises for an insured matter, a claim can be made on the title policy. Texas law does not require that the buyer get a title insurance policy. So, if in fact the buyer does not want title insurance, they do not have to get it. Most lenders, however, are going to require a lender's title policy. And if you get an owner's title policy and a lender's title policy at the same time, there's a simultaneous rate where the lender's policy is only $100. So we always recommend, if they're already paying for a lender's title policy, they might as well get the owner's title policy with it. Plus, the buyer can always negotiate that the seller pay for the owner's title policy. And this policy does provide more protection for a buyer. However, if it is a cash deal, so meaning there's no lender title policy going to be issued, and the buyer decides that they do not want an owner's title policy, then a title company cannot close the transaction for them. We as title companies cannot use our escrow accounts unless there is a policy being issued. Title policies are only paid for once, and they provide more protection than an attorney's title opinion. We always recommend your clients get a title policy, and most importantly, we recommend they use Allegiance Title. We are your trusted resource for results.